Good evening, good morning, good afternoon to everyone who's joined us today from India and different parts of the world for this second webinar in a series of webinars that we have been conducting as a part of the GW Competition and Innovation Labs India initiative. As the lead for the India initiative of the lab, it is my absolute pleasure to invite our moderator and panelists for this webinar today that is titled Indian Competition Law 2.0 Commitments and Settlements. I would first like to introduce the moderator, Professor Dr. Shilpi Bhattacharya, who is a professor at Jindal Global Law School. And I would also request Professor Shilpi to introduce our fellow panelists. Professor Shilpi, over to you.
Thank you so much, Professor Manveen, and welcome to all for this fantastic webinar. We have a very exciting set of people to talk about this very new and interesting development in the Indian competition law framework on settlements and commitments. So I'm just going to give a brief introduction to the framework to those who may not know about it, especially people from outside India. And then I'm going to introduce the fantastic set of panelists that we have, and we'll start our discussion. So India has introduced a new settlement and commitment framework under sections 48A and 48B of the Indian Competition Act as part of the 2023 amendments to the Act. These are voluntary agreements that are reached between entities who are being investigated and the CCI, or the Competition Commission of India. And they are essentially with respect to two types of anti-competitive concerns. Those are abuse of dominance and vertical agreements. They don't apply to horizontal agreements or cartels. So the difference between a settlement and a commitment, this is kind of unique to India, is that settlements are made at a later stage of the case after the CCI has received the report from the DG with the DG's findings. The DG is the Director General, but before the CCI gives its final order, while commitments are made after the CCI gives a prima facie order with respect to the initiation of an investigation into a case, but before the DG has given its report to the CCI with respect to its findings. The process to be followed, the timelines, etc., are provided for in separate set of regulations, which I'm sure our panelists will talk about more. These orders are final and binding on parties, and they cannot be appealed. But under Section 48C of the Competition Act, the CCI can revoke these orders if applicants have not made full and true disclosure, or there has been a material change in the facts of the case. So the whole idea of settlements and commitments, of course, follows sort of the general idea of this in other jurisdictions, which is speeding up enforcement of competition law, ensuring speedy market correction, more efficient utilization of CCI's resources. And of course, with respect to India, you have other things like ensuring the collection of penalties, which we've had a poor track record of in the past. And I also think it's helpful with respect to how the CCI can now, when cases are coming under this framework, really focus on designing remedies and pay more attention on that rather than on proving that conduct is anti-competitive. So the settlement framework is particularly aimed at digital markets where timely enforcement is essential, as markets can tip in favor of dominant players. And it's no surprise that India's first settlement order is in a digital market. It came early in this year in April, and it's with respect to the Android TV operating system market. The case is called Shutajarya versus Google. And it's also interesting that this case comes with a dissent note from one of the members of the CCI. And there is, of course, a lot of discussion around this in India within the practitioners and academics of competition law. And I'm hoping to really get into it in this discussion. And I'm sure our panelists will really highlight the critiques, the ambiguities, the limitations, as well as the strengths of this framework. As always, the devil lies in the details. So let's get down to the details of this framework. So let me begin by introducing the fantastic panelists that we have today. Our first panelist is Ms. Hemangini Dadwal, who is a senior partner with the competition practice of AZB and Partners. She has led significant antitrust enforcement and merger control deals in India. And most notably, she has led the first and only successful settlement case, which I just mentioned, the Google Android TV case before the CCI. She advises a number of large companies on antitrust matters, including Google and Bharti Airtel, and she's also a non governmental advisor to the Indian Antitrust Authority. So she comes with tremendous experience, and we're so thankful to have her. The next panelist I would like to introduce is Mr. Abhi Roy. He is the co-founder of Sarvada Legal, where he also heads the competition law practice, and he represents clients across a number of different sectors in various forums, including at the Supreme Court of India. He has authored a number of textbooks in competition law, including most recently Competition Law in India, a practical guide published by Walters Kluwer in March 24, which I also assign as reading to my students. So thank you so much for writing such a fantastic book and for being here today. It's really great to have you. And finally, last but not the least, we have Dr. Manisha Goyal, who is a senior economist at Econ One, an economic litigation consulting firm where she works on antitrust cases. She's also an associate professor of economics at Pomona College, previously at University of North Carolina. She has a PhD in economics from Ohio State University and nearly 2 decades of experience in economic analysis, econometrics, and machine learning methods. Her work has focused on competition laws in India and how they impact India's economy and domestic business. And I'm so excited for you to be here. Dr. Goyal, thank you so much for being here. So, with that introduction, let's get down to the discussion. So, the first question will be to you, Abir, to just set the stage for this. So, could you tell us a little bit about the strengths and weaknesses of the settlement and commitment framework in India, given your extensive experience? Sort of what you think is, the strong points and the weak points. What problems will this framework solve? What kind of cases do you expect will be filed under this framework? And also, do you think cartels should be a part of it?
Thank you so much. Thank you so much for the introduction and having me. Uh, so let me just briefly, I think, point out the couple of things that you mentioned in the introduction. The intent was faster enforcement and market correction. That was the essential intent of the CCA to bring these laws, and these are obviously voluntary in nature, in the sense nobody is forcing you to come and file a settlement or a commitment application. Now, be that as it may, obviously there are strengths, but I would like to point out certain open issues which will come up during the course of the implementation. Obviously, we have had one case, but I think it's too soon to say whether it will meet the objective. It has a good objective, let me put it this way, but where do I see the issues with implementation is number one, in a vertical agreement case, for example, because the law basically says that if, for example, that a particular player has filed a settlement application, the inquiry qua him or qua the enterprise will be held in abeyance, but the inquiry against other companies will be ongoing. Now, how will it practically work out? Because if there is an agreement which is the subject matter of the investigation, and one of the parties has come and says we want to file a settlement application, and if the investigation or the inquiry against that particular applicant is stayed or put in abeyance, how will the inquiry proceed against the other parties? So effectively, the entire matter will be held in abeyance. Practically, I'm talking about practical situations. This is the first thought that I had, especially in a 3-4 case. In an abuse of dominance case, perhaps it's more easier, because if the inquiry is held in abeyance, it's still fine. But in a vertical agreement case, while I understand and appreciate the objective behind it, we will need to see how it will practically work out. That will be I would say, something to watch out for in the future. That is point number one. Point number two is that in a commitment kind of a situation, which is immediately after the 26-1 order is passed, um, how will a commitment applicant understand what is the harm? Because without understanding or appreciating the harm, it is very difficult for a commitment applicant to come forward and say, okay, fine, I will do this or I'll undertake these steps so that there's no harm, or the harm which has been thought about at the start of the inquiry will be allayed. So that is another thing which, from both from a commitment applicant perspective as well as a CCI perspective, it will be something to watch out for. Third is another thing that I was thinking was, and I'm sorry to be the, while we all know the strengths, I would love first like to point out the, I won't say the weakness, weakness is the wrong word here, but I think the implementations will have to be seen. So I wanted to point out that. Third is, I think most of us, the competition practitioners, will know, and all across would know that at the 26(1) stage, you actually do not know the entity who is under investigation sometimes, because if you look at all the prima facie orders which are passed, they will essentially say that if the DG finds some other enterprise which is guilty, then they are also they are well within the rights to investigate the matter. Now, if that were to happen, and that has been blessed by the Supreme Court of the land, saying that DG is not circumscribed by the 26(1) order, they can go well beyond. And say, for example, they are at the initial stage, the investigation was against say two companies, and they find one more company which is engaged in a similar vertical agreement. Then what happens? Then when will that enterprise, which was not named in the prima facie order, come to know and file its commitment application? Because there are timelines in place. It may be too wrong to expect the CCA to again pass a 26(1) order, because you can't go back and forth because 26(1) is the initiation point, the start of the matter, and the commitment application has to be made within a particular time frame. So these are implementation challenges which may, or questions, challenges again is the wrong word, questions which may come up, keeping in mind that you're looking at a faster resolution which is there. If that is the end objectives, there has to be certain implementation questions which will come up. Another question which is there is, obviously you don't make a law for a person who will willfully disobey the law. But still, I would like to point out that perhaps CCA should have the power to go against frivolous settlement applications. So if there is obviously it's a subjective question, but if say suppose if there is a DG report which has found an enterprise to be guilty of vertical agreements on abuse of dominance, and then just to stop the process, you file a settlement application to delay the process. I guess CCA should have the power to under its laws or regulation to say that this is not helping the cause, because it was the intent was to delay the proceedings. So these are the few of the implementation thoughts that I had at the very beginning, which is there. As far as sectors are concerned, I think we had settlement and commitment. I think like deal value threshold, which is there. It may be thought about to being in a digital market, but the ambit is wide enough. You can have any sector which is coming in. Yes, we have had one case which is in the digital markets, but I think there will be more and more people who will come in once obviously they understand that there is a litigation arbitrage to have had here to settle the proceedings, have remedies which are under discussion, and then close the matter once and for all. So once that arbitrage is seen, I think there will be more and more companies which are coming in. So these were my initial observations. As far as I think your question on cartels is concerned, they the thought process was obviously you have the leniency application. So do you need a settlement and commitment? But I think one way to look at it, but I think it's too soon to think on those lines right now. But just a thought was that see, when you file a leniency application, it's more of a, obviously you get protections, plus there's an evidence gathering exercise. You need to obviously give all the information, full and vital disclosure, and cooperate with the DG throughout the process. So that is more of an evidence gathering or evidence perspective, whereas settlement is more of a closure of the inquiry process. So while there may be overlaps, the intent may be completely different. So perhaps at some point of time, like we have in EU, I guess, You can look into settlement in cartel cases just to close the matter so that effective remedies can be passed. But it is we'll see how that goes. These were my preliminary comments.
Thank you so much, Abir, for those very interesting points. I would like to next move on to Manisha. So, Manisha, as the economist here, so from an economist perspective, what do you envisage will be the trade-offs within the settlement and commitment framework, and the consequent impact this has on competition or enforcement? This framework has been called a game changer. Do you think it's going to be a game changer? How likely do you think it is to meet the objectives that it set out to achieve? And also, sort of anything you'd like to say in response to what Abir said? Over to you, Manisha.
Thank you, Professor Bhattacharya. This is, I'm very, very glad to be able to participate in this. And thanks for the generous introduction. I'm going to start by basically going back to first principles with regard to the goals as outlined in the new regime. And those two goals, as Abir pointed out earlier, are to reduce litigation and to have quicker market correction. And as an economist, my guess is that it will reduce litigation despite all the implementation challenges that Abir just pointed out. However, I'm not so confident that it will lead to quicker market correction. And here, I think there is a key distinction between commitments and settlement. And in my mind, commitment is forward-looking in the sense that, okay, I did some action which has been brought to the attention of the CCI, and I commit to not do the same actions going forward. So it's a forward-looking mechanism. But settlement is some sort of penalty that would be imposed because of the actions that you've already taken, maybe for a while. And in that sense, it is backward-looking. And I think there are problems with or limitations of both the settlement and the commitments that can lead to not achieving properly or having a missed opportunity with regard to market correction. So in the first case, which is of commitments, the problem that I see as an economist is that commitments are going to be very case specific. Therefore, they can be very narrow. And the parties who are committing to certain actions can exploit various kinds of loopholes. The general public or the other participants in the market, in the same industry, other firms, other businesses, may not really understand the rationale behind the commitments that have been offered, and therefore may not be able to figure out for themselves if they were in a similar situation, what should they do, or what can they do preemptively, proactively to avoid getting into the crosshairs of the CCI. With regard to settlement, I see a lot of room for improvement, particularly in the case of in the situation of settlements. And the reason is that the settlement ultimately is coming through these penalty guidelines. And the way I read them, I find them quite formulaic and quite arbitrary. And if we want to correct for the market, the anti-competitive actions that may have been taken, which are making the market less competitive, then the settlement amount needs to have a bite, needs to have a rationale, which is simply and transparently understood, not just by the parties involved, but by rest of the market participants, which are not currently part of the inquiry or the case, but are nevertheless going to be impacted by this currently or in the future. The way the penalty guidelines have been set up currently, they leave room for a business that has been found in violation of certain antitrust or competition laws in India to get away with very little. And so it might even be viewed by businesses as just a regrettable necessity a necessary cost that they have to pay in the course of doing business, and not enough of an amount that will make them think twice before doing some or taking some anti-competitive actions. Moreover, it may not have a deterrent impact going forward for the same parties as well as with the other market participants. And any settlement action, especially if it is supposed to create efficiencies not only in the court of law but also in the economics of the country and the market, should have a deterrent effect, so as to reduce litigation going forward and to correct market not just in the current context but also from prevent future such actions from happening. The way the settlements have been proposed for currently, I feel like there is a lot of room for recidivism by the same participants, and may not deter similar or more egregious actions even by other market participants in the future. With regard to the third point that Abir made about cartels, my purely economic view, rather than an implementation view, is that while we may believe that cartels are the most egregious form of anti-competitive actions, they are shockingly common. Many may go undetected, but when they do get detected, we begin to realize that those actions, or the ones that we have detected, are probably just the tip of the iceberg. And if we want to prevent cartels from happening or to catch them early on and make our commitments and settlements enough of a deterrent, then I believe it is a missed opportunity to not include cartels in settlements and commitments. And this is where the settlement amount can be really, really key, because we don't want to leave room for a future litigation seeking compensation just because a settlement did not go far enough. There is enough evidence that shows that even after cartels have been litigated against and settled or went into a trial, the effects of the cartel, even when they stop, are long lasting because they essentially change the market structure for the foreseeable future. And so not including cartels in the purview of settlements is a missed opportunity. I'll stop here and take more questions later on.
Thank you so much, Manisha. Those are such insightful comments for this lawyer community that you're sort of addressing. So thank you for that. My next question is to our sort of expert panelist here, who's actually experienced the process. So given that you have the badge of being the first lawyer to experience the system, Hemangini, can you tell us a bit about your experience with the system? What was the process like? How did it work in practice? How much was the CCI involved with respect to negotiating settlement terms? What changes would you want in the system? What are your takeaways from the system? And also, just very briefly, if you could tell us about the Google case and shed some light on that for people who are not very familiar with it. And also just any response you have to Abir or Manisha, that would be great. Thank you so much, Hemangini.
Thanks, Shilpi, and thank you also for the lovely introduction earlier. I do have some responses, but maybe I'll just start off with giving my experience in the settlement process. So yes, we were in fact lucky to be within the timeline, as you know, but some people might already know that both the settlement and the commitment mechanism is significantly time bound. Parties do not have the ability to sort of mull over the decision on whether to or when to approach the commission in a settlement and commitment application. There's 75 days that they have. In commitments, they have sort of 75 days from the time that the 26-1 order is issued. And we'll come to the nitty-gritties about how that can get a little complicated depending on those, if there is if the investigation is against more parties, like Abir mentioned. And the same in settlement. from the time that you receive the confidential version of the DG's report. And so maybe just taking that aspect first, which is CCI will not accept anything short of a complete application, which means that in the 75 days that the CCI either formulates a prima facie opinion identifying based on the evidence that it has a prima facie case of abuse of dominance or vertical restraint. So you need to immediately come up with solutions which will work. The applications and commitments and settlements are quite extensive. You need to address each of the issues that the CCI has identified. And anyone who is familiar with CCI's orders, the conduct could be one, it could be two, it could be three, and it needs to address each of the harms that the CCI identifies under its provisions. For settlements, it's even more challenging. In 75 days, you have an entire DG report. Again, those who are familiar will know that this can extend thousands of pages of evidence as well as findings, and then tailor a remedy which the parties believe will work with the CCI. And this also oftentimes involves a bunch of different, formulations. A is coming up with a remedy that works. B is running those internal checks. I mean, we're talking about, practices that have been engaged by the parties, and practices that have not been finally decided one way or the other as being anti-competitive, right? So you need to also hedge about, how much of this is actually likely to be a contravention later on, or is it, should we, sort of cut our losses in terms of the process, the timelines, etc. And it's really a cost benefit analysis as well, because I mean, in neither of those cases is the presumption that you are guilty, right? The entire reason, like Abir mentioned, is to reach a faster solution based on whatever evidence and information there is. In commitments, you don't have to pay a penalty because it's just an initiation statement. Very little evidence, you've really not done anything. It's really to stop going into sort of 10 to 15 years of litigation. Again, those who are familiar will know that from this, it's not just the CCI, which works reasonably quickly. Then you have the NCLAT, which can go into appeal, and then you have the Supreme Court. So by the time a decision reaches finality, there are several cases that started in 2011 and 12 that have still not reached finality, and we're now sitting in 2025. So look, we have to keep in mind the objective. It's not one of deterrence, it's one of speedy resolution, and reaching an implementable solution. Deterrence is, of course, in the form of penalties. Once you're found to be guilty, then by all means we need to have, and the CCI has immense powers, which has been only expanded by the recent 2024 amendments, which gives them the ability to penalize on global total turnovers, overturning a decision of the Supreme Court in the Excel crop care. So I think deterrence is sufficient, and that's maybe one point that I would strongly defer with Dr. Goyal on that one. But in terms of the process, I think it is. I think it's for the first time introduction and novel introduction, I would say, that India has come up with, that the Commission, the legislature has come up with for both commitments and settlements. I think it's a great start. Our own experience in this one case has been, I think I would really like to sort of, take some time to point out that the CCI, I think, did a fantastically professional job in navigating what was new. We were navigating something new. They were navigating something new. They took their time to make sure that all the I's were dotted, the T's were crossed. Every regulation that has been stipulated was followed. They also took the time to satisfy themselves that the proposal that was put forth before them met each of the harms that were identified in the DG report. The DG report, of course, is not public. It's with all the parties. But it's not, again, with settlements and with commitments, of course, the process is quite comprehensive, because you do have market testing as well. So it's not just between the Commission and the party, because at the end of the day, this is remedies over here are, it's not just, between parties. The CCI needs to be satisfied that the conduct is going to address the harm in the market. And so there is extensive market testing that's done. A statement of the proposal with reasonably extensive details is circulated to every party that has participated in the DG's investigation process. And again, for those who are somewhat familiar with the investigation process at the DG stage, would know that that's a very extensive list of people that the DG reaches out to. Amongst different stakeholders. So in the tech space, there could be OEMs, there could be app developers, there could be, anyone and everyone that the DG can consider relevant to their investigation. And so each of them are individually reached out to. Their comments are sought. Those comments need to be addressed by the applicant to the satisfaction of the commission, and only if the commission, and then the commission may have some more clarifications which they can ask over and above what they have received from the market study, and the applicant would need to satisfy them. And all of this is done within a 180 day timeline period, which is again not significant, to reach a conclusion or reach a solution that addresses each of the harms that have been identified in the DG report. So I'd say, given the mammoth task, given the objective, for the introduction of the settlement and commitment regime, I'm speaking more towards settlement, having just done this, but equally the commitment regime, I think it's a great start. Yes, there are maybe some facts, fact patterns that may not have been envisaged. That happens, constantly in merger control. We've seen every year the combination regulations, for example, need to be updated more or less, because, as transactions change, as transaction structures change, you need to move the law along with that. And so is the same case here. There will be novel and unique facts to each case, which may not have been envisaged when a framework was being developed. And I think those can be addressed by way of, say, FAQs or further engagement discussions like this, frankly, where certain issues can be brought up. I think this is a great start. And to your initial comment, Shilpi, which is that this is a game changer. I think this is definitely the start of a changer, as it were, because there's been a lot of discussion, especially when it comes to digital markets, about reaching solutions quickly. And this is one way of doing that. I don't think this is the way. There's no one right way of doing it, but keeping those goals in mind, this is certainly one of those ways of doing it. You also asked in terms of, what the process was. So I'll just very quickly run through it. This is pretty, straightforward. You have to file an application, again, within a time-bound manner. One of the reasons why we probably just have one in the pipeline is also because, or rather one decision for settlements, and maybe not yet a whole lot of these decisions, is because the applicant who needed to be within that timeline when the regulations were issued. I believe this was around early 2023, I think, when the regulations had come out. You had to be within the 75-day period of when the confidential report was issued. And at that point in time, there weren't a whole lot of 26(1) orders that were that had recently been passed for commitments, or in terms of abuse of dominance and vertical restraints. So that may be another reason why it might not, you're not seeing a whole lot of these applications right now. Once the application is filed, it needs to be complete in all respects. Otherwise, the CCI will reject it outset. And when I say complete, it means all the allegations need to be addressed, and a solution for each of those need to be provided. If the CCI feels that everything is complete, then the process is put in the contravention proceedings under Section 26 are put in abeyance. And then you follow on with market testing. Third parties have about 21 days to respond. They're reached out to individually. In the case of at least settlements. For commitments, it would be a different process because there aren't any sort of third parties that were identified in an extensive investigation. So there'd probably be a more public kind of comment receipt mechanism. And once, again, with moving on to settlements, once those comments have been received, you need to address. CCI will address all, will ask certain clarifications, etc., and then will give you a number, and that number is your settlement amount. Again, I think sort of Dr. Goel did mention that the whole settlement mechanism and the fact that the settlement amount might not be a deterrent enough to do that. I think it's also important to recognize that this is a voluntary mechanism. People, if you're going to be fined the same amount that you feel like you would have to take your chances before in a litigation process where you have 10 to 15 years to litigate and two different forums before which you have the ability to convince the judge that my conduct was kosher, uh, where is the incentive, right, for parties to actually put forth in this kind of challenging environment to come up with these remedies, etc.? So I think that balance is important to do, and it's not like the CCI does not have several tools in its belt, including, and to Abir's point, which is that if it gets revoked, or if the CCI feels that true disclosures were not made, you can use all of that information that any other party has given during your, say, settlement process, and use that to initiate, when the proceedings against the applicant resumes, because your settlement order has been set aside if you haven't made full true disclosures, or if certain part of that settlement didn't work out in the way that was portrayed to the commission. So keeping all of that in mind, I feel like my summary of this would be that it's a very good start. I think the first time implementation was a good implementation. I do have a wish list, but I don't want to take up time for everyone else as well. So I'll maybe come back to that in a bit. I would just maybe 2 points to highlight there is that it would be good to see more engagement, just like we have with merger control. Parties engage a lot more with the case teams and try and understand the industry and understand the product and the process, etc. And it's because it's not adversarial. And what we need to recognize in commitments and settlements is that adversarial nature is paused. And so we're really trying to just work towards reaching a conclusion that would address the market harms, or the perceived market harms. I would continue to say perceived market harms because there's no decision yet. And the timelines. I feel like the timelines is something that it's too short a time frame. I understand that the whole purpose is to reach a decision faster, but 75 days or 180 days versus 12, 13, 14 years, I think we can give a little bit more to this process in terms of timelines, to wrap it up, in order to really reach a solution that works. In our case, it worked great. It might not be, several industries could have different facts, and you just need, and for a process not to work purely because there wasn't enough time would be a little tragic. So I'll pause there and happy to take any questions after.
Thank you so much, Himangini. That gave us like such a wonderful insight into sort of how this process works in practice. And clearly, you did not sleep for 180 days. It seems it was very intense. But all of you have highlighted on the timelines as well, and I'm looking forward to hearing your wish list later, Manisha. So we'll hopefully, Hemangini, will look forward to hearing your wish list later. So I'm hoping we can end with your wish list. That will be really nice. So now I'd like to come back to Abir and then to Manisha. Abir, also you could respond to what the others have said, but also do you have sort of any comments on sort of on the settlement order that we have, the dissent note? Do you think that the order reflects an effective remedy in the market? What do you expect broadly in terms of the future for the settlement regime? You've already highlighted some very important concerns, but just in terms of taking a more futuristic outlook. And also, my last question would be, this is to all of you, like all three of you, you can address this, is do you think that this is going to be an effective replacement for ex-ante regulation in digital markets? Do you think that it can do what ex-ante regulation was supposed to do? Because some people have talked about that in the context of the settlement regime. So I'll start with Abir. Your thoughts.
See, I'll take the last question first. Like you mentioned, is it an alternative to the ex ante regime? The answer is, in my opinion, no, because ex ante regime is supposed to operate if they come. If they come again, a disclaimer here. Uh, there are certain issues with the proposed digital competition bill, which I perceived there are. But let's park that discussion for some separate time. But I don't think this is an alternative because, firstly, the settlement commitment, like everybody of us mentioned, is a voluntary regime. That is one. Secondly, the ex ante proceeds on a fact that there are certain platform services and there are certain companies which will be designated as gatekeepers which are supposed to do certain activities. So that proceeds on a different footing, and settlement and commitment is both. Basically, there's an investigation report, and the parties voluntarily come forward to settle the matter. So I think a very brief, without going into too much technicalities, I don't think they operate in a completely different sphere. So that is my view uh, on the last question that you mentioned. Couple of points which is there on the existing Google matter. See, one thing which is there is, and this is an observation, and not trying to say that I'm evading the question. I think the settlement order, when it is there, it should be much more, I would say, there has to be more details in that order. I think the intent was there to settle the matter, and I completely echo what Himangini is saying, that I think timing is an issue, especially for a global company, wherein because there are so many stakeholders, global practices which are there. At times, days being so shortened may be an issue, but I think the details, there should be more details in the settlement order for how that affects or how that allays the market issue. And both, I'm talking about both the main order and the dissent note. Dissent note proceeds on the fact that it's not a full settlement because under the CCI regulation there is no partial settlement, but that is on the legal principles. If you actually talk about the market corrections and what was the market harm, I think some more analysis is something which I think as a reader I would have expected, having no involvement in the matter. So that is something from a reading. I think there should have been slightly more emphasis on that. And the reason why I say this is tomorrow, for example, I think what one of the panelists also you mentioned that Dr. Manisha, you mentioned that, for example, settlement is basically for past conducts. So if, for example, somebody were to file a follow-on or a compensation application, while settlement application is not a acknowledgement of guilt under the regulation, but it can still lead to follow-on actions. So, what was the harm that the DG saw? What was the harm in the market, which existed previously? Some kind of analysis. It's maybe sometime which maybe something which may be warranted. Is my first I would say observation in this matter. Secondly, not going to dissent and the main order. I think more clarity should have been required. That is my observation. On the overall, like I said, I think most of the laws which are there, including the exports competition law which is there, the idea has always been speedy resolutions. But I think the lot of thing which is there is actually in the implementation, and the implementation has been found to be could have been better. Let me put it this way: could have been better for multiple reasons. So we'll see how this will go. I think this is a good start. And just to add to Himangni's point, I think one thing which is also there is not only is the notice sent to third party, the notice is sent to DG. And Himangni, correct me if I'm wrong. It's as per the law, it's also sent to the DG. So even the investigating authority also can give its inputs. So that is also a very good scope which is given under the act. So I think the investigator who has investigated the matter can also give its recommendations to the CCI, which is the final adjudicatory authority, that okay, fine, this settlement terms that is being offered, does it actually allay the concerns? So So those are right, I think, the right steps which are there. Obviously, there will be difficulties, like I mentioned initially, and in all the regulations, CCA has the power to remove difficulty. There's a clause for removal of difficulty. So that is something which they can always rely on and regulate its own procedure on each individual cases. But I would, if you really want the settlement regime or the commitment regime to properly work, couple of, like, if I may conclude, couple of wish lists without getting into too much detail into the procedure. First wish list would be the settlement or the commitment order should be slightly more detailed. That is my first, I would say, learn as a student of competition law. That would be my first request. And the second is, will it be fine, without giving in a view one way or the other, that should the non-confidential version of the settlement or the commitment application or the proposed terms, should it be open to public like the 26 one order for comments? Because obviously you have third parties in a settlement matter, but for commitment, perhaps you can have a section on the website where you have the 26-1 order and say that this is the commitment order application which is there. Please give your comments. So perhaps these are the two, I would say, on the top of my head, which wish list which is there. But I think overall it's the step in the right direction. But then to assume that this is a alternative to ex ante, I think that may not be, uh, that is, to my understanding, may not be the right approach.
Thank you so much, Abir, for those excellent points. Over to you, Manisha, and also if you'd like to respond to anything Abir said.
Thank you, Abir. I'm also going to talk about ex ante versus the settlement commitment regime, and then go back to some comments that Himangini made and my response to them, and a few other things that I would like to highlight in terms of trade-offs. So I absolutely am in agreement with Abir that this is not at all a substitute, not even an imperfect substitute, for ex ante regulations. As an economist, I always have seen that every policy, no matter how well thought out and how well intentioned, comes with trade-offs and often has consequences that are not intended. Ex ante regulations are particularly fraught in this regard. I recently investigated or examined the provision of in the proposed draft for digital markets, which relates to self-preferencing, and I wrote an article which talks about how self-preferencing, in an outlawing self-preferencing via ex ante regulations, can actually do more harm than good, even to the very parties that you wanted to benefit through that regulation. So ex ante regulation, unlike settlements and commitments, do not have a step two. Once it has been outlawed or said that it is illegal to do, then that's what it is, and everybody has to follow that, and otherwise be in the crosshairs of the law. On the other hand, the settlement commitment is not set in stone the way ex ante regulations would be, and they leave room for take two and take three and evolution of revamping the commitments or going to the compensation path in case the market situation changes or if it was not found sufficient in the first place. In that sense, settlements and commitments are, in my view at least, almost better than ex ante regulations. And ex ante regulations should be reserved for a very small fraction of actions that are deemed per se illegal. I mean, for example, if you take a parallel to outside of competition law, like murder is wrong, yeah, everybody would agree with that, no matter what situation. And that is per se illegal, and ex ante is outlawed. So similarly, in competition law, there should be a very, very small set of things that should be ex ante regulated out. Going back to settlement versus trial, and we want to reduce litigation, we want to have expeditious settlements, expeditious resolutions. I am absolutely in agreement with that objective. There is a saying which says that a bad settlement is better than a good trial. And I am on the side of bad settlements as being better than good trials. And the reason, again, is, as Hemangini pointed out, trials can go on for a really, really long time. Not only is there direct cost involved to the parties as well as to the courts, there is also opportunity cost of all the time and the resources and the effort that is being spent on these long drawn protracted trials. So the courts could have been doing other things. They could have been taking up more and more important cases, which would not be if they are stuck with long standing trials. Similarly, the businesses, they have limited resources, limited time, and if that is being spent on these long drawn protracted trials, then that is taking away from more innovation and more product improvements and entering new markets, expansion, hiring, all of that, which is critical to the survival and thriving of a business. So bad settlements are better than good trials because it creates a regime of certainty, both for the courts and for the parties involved. However, how bad can a settlement be? And that is where if you do not tip the scale towards too bad a settlement, then you can simultaneously achieve the goals of reduction in litigation and quicker market corrections. You don't want to settle just to give the appearance of a market correction when you haven't really corrected for the market. So instead of doing these formulaic, the penalty cannot be more than 10% as currently drafted. The penalty cannot be more than 10% of global revenue or relevant revenue. And relevant revenue, it sounds like a simple term, but that the devil lies in the details. As an economist, when I work on cases in the world of competition in the United States and Canada, what is that relevant revenue? A lot of expertise goes into defining what the market is. It's not a science, it's an art to define the market. And therefore it is not obvious what the market is. And given that it's not obvious what the market is, therefore it is not obvious what the relevant revenue is. And so if you're going to define that relevant revenue and then decide what is the harm done, then instead of taking a formulaic approach, you have to have a whole lot of data analysis. And here I would echo both Hemangini and Abir in that kind of data analysis and market research, industry research doesn't happen overnight. And therefore 75 days or 180 days is too short a timeline to achieve meaningful analysis for what the relevant revenue is and what the damage done is without presuming guilt. And when you do the data analysis, you don't have to assume guilt. You just take the data as they are and let the data reveal what has happened in terms of prices or exclusion or harm to competition or harm to consumers or harm to workers, whatever the case facts may be. And so when you're correcting for the market and you go and you really lowball the settlement amount, I'm not saying that that's what happened in the one case that has come to a decision so far. If you really lowball the amount, it doesn't really fix the market, even if it gives the appearance of fixing the market. I have worked on cases which have been settled where we analyzed, for example, that the damage was more than $1 billion, but the settlement came to less than 50% of that amount. That itself was a huge amount, and could work to fix the market to undo the effects of the conspiracy that had been a long-standing conspiracy. But that is when you are trying to correct the market in a quick manner instead of leaving something for 15 years, creating a lot of uncertainty in the meanwhile. And so I'll just stop there in the interest of time.
Thank you so much, Manisha. And I want to give the last word to Hemangini. So Hemangini, your responses to everything, as well as to the question, to other people, as well as your wish list, I'm looking forward to hear from you.
That's a lot to cover in 4 minutes, but I will try my best. Maybe just to take where Dr. Goel left off first again, and my understanding is that a penalty or a settlement amount can never be to fix conduct in the market. It's the purpose is to deter that conduct from happening again, and the amount if and it's to and so that's the objective of imposing a penalty, to make the company pay, bearing in mind that there is no final decision over here, and no final the regulator, the authority, has not even reached a decision on whether the party is guilty or not. And in the way this has been framed, you get the CCI will come up with a number, and the party has to either accept or reject that number. There is no negotiating with this number. Fully agree that this takes time. It's especially from the company's perspective, because they really need to weigh the pros and cons. Should I take my time to fight this out, or should I just settle this amount? Because right till the end, I mean, because there is no decision on guilt here, uh, and depending on there is lots of reasons why you might want to continue or to stop. So I think that analysis is also one that takes time, and you have 15 days to either accept or reject a particular amount. So, and up until then you have no idea what that amount can be, so it's even more challenging. But if you really want to make a company pay, there's like somebody mentioned, there are compensation applications in settlements that are allowed. So if you feel that if you're able to show the appellate authority that you have suffered damage, and again, abuse of dominance and vertical restraints is different from collusion, and of course treble damages don't apply in India regardless, but it's not generally in competition not considered as egregious as cartel or collusive conduct. And so there is opportunity for the company to pay, although again, we really need to first reach a conclusion of guilt, which is absent in this entire process. To the second point, I think that everybody else raised, which is and your question should be, which is, does this replace or is it a good substitute at all for ex ante? I mean, overall, my views on ex ante regulation is, I think I'd echo both Abir and Dr. Goel here to say that I think this is especially when you compare to commitments and settlements, which I think is a step in the right direction. I don't think ex ante regulation is. There's just no information that is there. Empirical analysis, I've said this several thousands of times, and I truly believe that there is, to start outlawing conduct without undertaking data. So even before a presumptive rule was set for cartel conduct, 100 years of case studies were done before the presumptive rule against cartel has been sort of established and widely acknowledged across global jurisdictions. And I think while it's important to have faster resolution, you can't take a hammer to something that is as complicated as digital innovation is. Um, while we're talking about regulating big tech, you have AI that is a disruptor in the market, very frankly. So I think even as we're discussing, these bills, we've already moved on in terms of technology. So that's important. I think the objective of the two is the same, which is speedy resolutions. I don't feel that but the process to get there is very different. So speedy resolution or the objective cannot be a good enough argument for one to replace the other, although I feel like ex ante regulation more generally needs to be seriously looked at, especially in the way that it was introduced. And that was on that. My wish list, which I sort of touched upon both, and I don't really have much time to get into the details, but time, I think the time to put in your applications, as well as the time that the law takes, or the law gives parties and the commission, frankly, and third parties, to come up with their thoughts on to resolve this is too short. It should definitely be longer, especially given that without this you're up about 10-15 years. So I think you can give a couple of years for this and give parties a little bit more time to think through how and best they want to do this and to reach a solution. And I'd mentioned engagement. I think more engagement, uh, because we have now stepped out of the adversarial role or paused the adversarial process while this is going on. So if you really do want to give the commitment and settlement mechanism, uh, really give it a chance in reaching the right solution, I think more engagement with all the stakeholders to really understand and also explain. One of the things that, I mean, I'll tell you this, that the settlement order actually has all of the relevant details. We haven't spoken about the Google case, but it really is about breaking the tie between the must have apps versus the suite that is pre-installed. And the remedy here, I mean, I may be biased, but the remedy here did address that very concern. And so there isn't a whole lot more that needed to be said or is frankly a part of this case. And so it's all the relevant materials. And I know that the CCI was very, very conscious of making sure that the details were out there. Maybe it was just this fact, but even if it was a full-fledged order, I doubt that more details will be able to find its way into that decision. So yeah, those are definitely my two key wish list items for both these processes.
Thank you so much, Himangini. So that was really insightful, and thank you so much to all our panelists. I think we had such a fantastic discussion. Thank you, Abhi. Thank you, Manisha. Thank you, Himangini. It was fantastic. So I think I'd just like to end by kind of re-quoting what Manisha said, that a bad settlement is better than a good trial. So I think all three of you have said that this is overall a good thing, but a number of issues need to be sorted out, and we need to prevent sort of frivolous settlements. We need to make sure that the settlement terms are rigorous. Timelines are an issue, and the nitty-gritties of the settlement framework really need to be ironed out. Himangini talked about maybe having FAQs. So some really interesting points have been made. And I think we had some great disagreements as well. So we had a fantastic discussion. Thank you so very much to all of you for giving your insights here.
Thank you for having us.
For moderating. I enjoyed myself thoroughly. So thank you for that, and thank you, GW, for setting this up. Really enjoyed my time here, and my co-panelists for making this such an interesting discussion.
Thank you, everyone. Thank you for having us. Thank you for organizing this. Thanks to GW, and also special thanks to Manveen for inviting me in the first place.
Yes, thank you so much. Thank you, everyone.
Thank you, everyone. It was a pleasure. Thank you.
Thank you.